The press is often referred to as the fourth estate, to hold the other three branches of government accountable, to censure the government when necessary, to call it out. It can't do its job if the government controlled by Donald Trump prevents it from asking questions, from roaming the halls of power. And the Pentagon has tried to do that, and now the First Amendment is on the march. We've got a breaking order coming out from Judge Friedman, senior status judge in the District of Columbia, who has just found that the Pentagon and the Trump administration has violated his order by kicking the reporters out of the Pentagon, not allowing them back in without credentials, which are being held hostage, and they can only go into the Pentagon with escorts. No, says Judge Friedman, that's exactly what the framers and their founders said you could not do under the First Amendment. And now he's ordered the government once again to put the First Amendment freedom of the press reporters back inside the Pentagon, unlock the doors, let them roam freely, and ask the questions they need to ask in order to hold this government accountable, especially at a time of war. I'm Michael Popak, you're on Midas Touch. Let's get to the breaking news story with Judge Friedman's order. The New York Times brought the suit originally in order to get 7 of its reporters, including Julian Barnes, their credentials back. As you know, or you should know, the journalists were all kicked out, especially when they tossed in their badges rather than sign a policy that said they could not ask questions. They could not ask questions about classified, even non-classified information. That the Pentagon would be the ultimate arbiter of whether they were going to be able to report on something which is a violation of their First Amendment right, the freedom of the press, its viewpoint-based discrimination, which the Supreme Court loathes, and it completely destroys the structural element of our democracy, which the Founding Fathers and the framers of the First Amendment in 1789 put in the First Amendment, which is that the press is to be for the governed, not for the governors. And when a federal judge who's been on the bench for almost 40 years has to start his opinion with a reminder of what the First Amendment says, you know, things are not going to go well for the Pentagon. Let's get to it. Thanks for being here. Come over to Legal AF YouTube channel as well and hit the free subscribe button. Here's Judge Friedman, who's pissed off that his order was violated. See, he set an order 2 weeks ago blocking the Pentagon's brand new 12-page policy that they required all the reporters to sign that said, well, you can ask questions, but it's got to be with an escort and you can't go into these areas. And if we don't like what you're writing, we might even criminally prosecute you. And the judge says, you can't do any of that. You can't do any of that because they are reporters. They are the free press. And so in response, within days, sometimes hours of the judge's order, they issued a new policy. And who'd they do it through? They did it through another of Donald Trump's former criminal defense lawyers, a guy named Tim Parleratore. Now, Commander Parleratore, who I think was in the Naval Reserve, who they brought into the White House to babysit Pete Hegseth, you know, to be his lawyer and his spokesperson. You know, they had Parleratore sitting on Hegseth. So Parleratore and his group of press secret of press spokespeople or media spokespeople at the Pentagon created a 12-page memo that was even worse than the first one. And then immediately closed the correspondence corridor, the area, it's what it sounds like, the area at the Pentagon where the press was able to do their work. And they made it sound like it was a good thing. Well, we're kicking you out of the correspondence corridor, but good news, everybody. We're building an annex. We can't tell you when. It's not ready yet. Some sort of shed they picked up at Home Depot, I guess. And they literally wrote, but you'll have Wi-Fi and your cell phone will work. Oh, thanks. Yeah. So New York Times ran back into court, filed a motion to compel that they were violating the order. And here is what Judge Friedman had to say about that. He starts with the First Amendment proposed by Congress in 1789 and ratified in 1791. The First Amendment to the Constitution provides that Congress shall make no law abridging the freedom of speech or of the press. The First Amendment, the opinion continues, empowers the press to publish what it will and the public to read what it chooses, free of official prescription. In the words of Justice Black in the First Amendment, the Founding Fathers gave the free press the protection it must have to fulfill its essential role in our democracy. The press was to serve the governed, not the governors. The government's power to censor the press was abolished so that it would remain free to censure the government. The press was protected so that it could bear the secrets of government and inform the people. Only a free and unrestrained press can effectively expose deception in government. And paramount among the responsibilities is to prevent any part of the government from deceiving the people. That's what we do every day on Legal AF and on the Midas Touch Network. That is part of our molecular structure to hold power accountable to stop the government from deceiving people. We take our First Amendment right seriously here. And of course, so do federal judges like Judge Friedman. Now, the reason that the press is often referred to as the fourth estate, coming out of sort of a British analogy, is that the three estates, at least here, are the judiciary, the executive and the legislative branches. And the fourth branch, or the fourth estate in, and as important at the seat of the table as a stakeholder for the American people, is the press. So after going through that, he then goes through the order and the policy, and he says, no, you can't just say, well, we'll change the policy, but in spirit, you're doing the exact same thing I told you not to do, and say, well, sorry, it's a new policy. You can't enjoin it. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building a what we started together on Legal AF, I've launched a new law firm, the Popo Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Pope Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years. So my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment, harassment, or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Pope Firm today at 1877 POP AF or by visiting my website at www.thepopfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Poppy Firm fighting for your justice every step of the way. In fact, the judge says quite the opposite. I will order you to immediately give the badges to the New York Times, hence the press being back in the room. It says on page 9, rather than comply with the order, the department has cut off all badge holders, giving them meaningful access to the Pentagon. When assessing a litigant's compliance in the posture of an enforcement motion, a court need not accept a dubious literal interpretation of the injunction, particularly where that interpretation is designed to evade the injunction's goals. And in fact, he's not believing a word that they have to say. In particular, he says that in the context of the First Amendment, the policy's restrictions is on page 11 on journalists seeking information was unreasonable in light of the purpose of the Pentagon's press spaces, and the policy amounted to viewpoint discrimination, which is barred. Then he talks about how just like hours after he ordered the credentials be returned, they effectively got rid of the correspondence corridor. So on page 17, he says, in light of all this, the court has no choice but to conclude that the department's abrupt closure of the correspondence corridor and its ban on credentialed journalists traveling unescorted through the Pentagon are not security measures or efforts to make good on prior commitments, but rather transparent attempts to negate the impact of this court's order. The point of the court's injunction was to restore the Times journalists access to the Pentagon, not merely to ensure that they had possession of a physical credential. See, the Trump administration and the Pentagon was like, well, we gave him a badge. We're good now, right? No, we're not good. And here is how The court concludes about the power of the people to influence outcomes like this one. In fact, he refers in his order to letters and postcards received from people, the judge, after his first order, and he actually recites one of them as if they are as important as any court pronouncement or any learned scholar pronouncement. You know that it's the people speaking. The court cannot conclude this opinion, he says on page 19, without noting once again what this case is really about, the attempt by the Secretary of Defense, that's Hegst, to dictate the information received by the American people, to control the message, so that the people hears and see only what the Secretary and the Trump administration want them to hear and see. The Constitution demands better. The American public demands better too. Over the past few weeks, the court has received dozens of letters and postcards from people across the country explaining what the First Amendment means to them. To quote one such letter, quote, "A free press is essential to the success of our democratic republic. The people are the government, and they cannot make good, well-informed choices without all of the facts. A free press is an excellent place to start. See, our voice matters. It's penetrating, it's piercing, it's ending up in the ears and on the pen of federal judges. They watch No King's Day, hands-off marches, the tens of millions, hundreds of millions of people who have now marched. It matters. It gives the federal courts confidence and courage. Our courage gives them courage to speak out against the lawless, rogue Trump administration and its assault on fundamental rights. There's no other way to put it. I mean, we actually have additional reporting in this area that this is not the only place within the Trump administration where they're trying to use the press room for propaganda. We see it every day with Carolyn Leavitt, the press secretary. You know, all she gives is propaganda. All she is a political hack, an arm and extension of the Trump campaign, an arm and extension of the Trump organization business model. That's all we're watching. And I'm not even talking about, this is only about giving credentials to legitimate members of the press to be able to roam the hallway in the Pentagon to do their job. You know, all the things they were asking questions, having free access, knocking on doors, being told unclassified or classified information. That's the job of a reporter. That's their job description. That's what the Pentagon policy was trying to bar. Now, we still have a situation where the official Pentagon briefing room is not filled with legitimate First Amendment freedom of the press reporters. It's filled with MAGA right-wing social media influencers. Laura Loomer is a regular and has a pass into the Pentagon briefing room. Laura Loomer, the rightest of right-wing podcasters, when she's not sitting up in some trailer somewhere in North Florida, she's in the Pentagon. Matt Gaetz, remember Matt Gaetz used to be a congressperson from Florida. Now he's a podcaster. I don't think anybody watches him, but he's a podcaster and had a sticky little problem of being alleged to be a child sex trafficker. Remember that guy? Didn't make it to the Attorney General spot because of it. Yeah, he's in the room asking questions. You know, the Riley Gaines of the world are in the room asking questions. This is not the Fourth Estate. We won't allow it. We won't abide it. And we'll continue to cover it here on Midas Touch and Legal AF. I'm Michael Popich until my next report. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or an oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called Wait for It, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack.